case briefs, and so much more. LSData's got what you're looking for.
A U.S. District Court in Louisiana ruled in a 1969 case, Solet v. MV Captain H.V. Dufrene, that a vessel owner is held responsible for ensuring that a vessel is seaworthy at the start of a charter and can be held liable for injuries caused by unseaworthy conditions. Deckhand Auguste Solet sued vessel owner Elvin J. Dufrene after a defective weld caused injuries, while Solet was lifting a net using a winch on the MV Capt. H.V. Dufrene. The court found the vessel to be unseaworthy due to the defective weld, and awarded the plaintiff $22,000 for personal injuries and loss of earnings. The defendant was held liable for breach of warranty against unseaworthiness, and the ship owner was held liable for maintenance and cure based on the employment relationship. The plaintiff was awarded $1,248 for maintenance and cure, $52 for first aid treatment, and attorney's fees and damages. Judgment was ordered against the MV Capt, H.V. Dufrene, and Elvin J. Dufrene for $15,400, $22,000 less 30% contributory negligence, plus 5% interest for injuries and loss of earnings.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.